Let's call to rise.
Well, two short final points, if I may. The first of them is to finish off the points I was making about purpose, and is a point which the court is already alive to, I'm sure, which is that the purpose does not extend to the requirement for Rule 45 to operate with all its procedures in every case in which there is a drop, for whatever reason, below what my learned friend describes as normal association.
Can you just say that again?
Yes. My learned friend's case, as you know, is that this trigger is normal association. If you drop below that, then there's a requirement. And we respectfully submit that that has some pretty surprising consequences. I mean, you can argue the toss, no doubt, on some of the cases, but at least opens up risks that you would then require that whole process to be followed for people who were transferred to vulnerable prisoner units, healthcare units. As my Lord Justice Hamlin pointed out, it isn't just good order and discipline, it's in their own interests, as the introductory words to that rule, and a whole variety of different circumstances where you are dropping for whatever reason, perhaps even temporarily for reasons of shortage of staff, whatever it may be, you drop below normal, whatever that may be, and all of a sudden you're into this rule. And that cannot have been the intention. We set them out in our skeleton at paragraph 29, and I don't go through them, but you have the essential point that there is a policy problem if you condition the application of this rule upon normal association. That's the first point I wanted to make. The second is a point that goes back to the rules. Can I invite you to go back to the rules behind tab 1 in the authority bundle? And it's a short point building on the points I've already made in relation to Rule 46. And this is a point that is related to 46.3. I've already made the points that 46.3, a bit like 45.3, permits, as it were, expressly on its face. So tab 1, Rule 46, permits on its face the, as it were, relaxation, so as to allow some association within the structure of the rules. But the 46.3 slightly discrete point is that if you try, and as it were, it's a point that aims at destruction of my learned friend's case rather than necessarily enhancement of mine, but it probably does both. If you try and put the word normal, which is his case, into association, and you do that in 46.3, that rule ceases to work. Because it is evident that it is permitting the resumption of association for people who are in CSCs within the CSC itself.
Which is impossible.
Exactly. And what that demonstrates is that even if there were doubt about how 45.3 works, which there isn't, but even if there were, you still, the rules can't be construed to mean something different as between the rules themselves. It's a point we made in the skeleton, 45 and 46, the concepts must mean the same thing. But the clearest example of the impossibility of inserting the word normal notionally into these rules is 46.3. My Lords, those are the submissions I wanted to make on the interpretation issue. I've been short, but I know my Lord has already told me that you've read the skeleton and everything we say in the skeleton we stick to, as it were.
Okay, that's fine. Thank you very much. Yes. Mr. Squires, do you want to reply on that first, on your appeal?
Yes. No, I wasn't sure whether you could carry on articulate, but no, I can reply. My Lord, a couple of factual points on the, we said in relation to the CSC inspection report, well, this is March 2015, and he was placed in the unit in November 2016, and that things had changed from there, and the reference he gave was...
We read the fast. March 2015, What?
Was the report. He's moved into the unit.
Which report?
This is the this is the chief inspector's.
Right. Which tab just this I've got it for the reference.
That is 18.
The 18, right? Fine.
Yeah, chief inspector's report, March 2015. In the unit.
Is that the supplementary bundle?
No, it's the
Bundle.
authorities bundle.
Right. Yes, that's. Then Mr. Syed is placed there in November 2016.
And it is said conditions had changed by then, and the reference you were given was Waldron 1 supplementary bundle, paras 8 to 9. And it may help, my lords, just to turn that up so I can make this point. It's supplementary bundle, page 21. And my lords will see from that, in fact, in terms of the conditions in the unit, it's not said that anything significant has changed. The most important change is a new officer has been appointed. He's been in post since December 2016, and he's going to be looking at ways to enhance the unit.
And that's in the context of the description he's given about those units.
Well, yes.
And I assume there's no issue about that.
The description of the unit.
Well, yes, probably paragraph 4 to 7. 4 to 6.
Well, no, that does take me on to my next point. No description in principle of how the unit might operate, but this point is picked up in terms of the description that's relied on by the Secretary of State of the conditions in the unit. And the point we make, my lord, it's that Mr. Eady adopted what was said in the Secretary of State's skeleton argument as a description of the unit, paragraphs 14 to 18. This is their Article 8 skeleton.
Have we finished with Mr. Ward?
Well, yes, yes. And in that description, the only point we make in reply is that one needs to be careful with that description. For example, at paragraph 16, it sets out things that prisoners may be able to have in the unit. And this was, pick up my Lord Justice Hammond's point, that we don't dispute that that may in principle, and this the same with Mr. Waldron's statement, things the prisoner may have in the unit, but the critical question here is what did this appellant have during his time in the unit? And for example, he doesn't have education off unit, doesn't have work off unit, those are C and D, etc.
But if we're looking at the meaning of the rule, it's relevant to have regard to more generalised evidence, isn't it?
Well, possibly the question in this case is whether Mr. Syed was removed from association, and so therefore it does matter. Once one decides what the meaning of the rule is, the question is whether the conditions to which he was subject constitutes removal from association. So we do say, therefore, it matters how he was particularly treated, and whether that counts as removal from association. There was a question was asked, Mr. Eady, about how long Mr. Syed was out of his cell for in total, and we get it. It's paragraphs 20, 21, 24 of the judgment below, and essentially it's that he was out. He was able to. He had association time. The maximum was 2 hours 15. Minimum was 1 hour 30 if one looks over the different weeks. Those are paragraphs 20 and 21. He also had 1 hour exercise in the exercise yard. And so that gives a total time unlocked from his cell of between 2 hours 30 and 3 hours 15. And so he was locked up 20 hours 45 to 21 hours 30.
20 hours 45 to
21 hours 30. I mean, that's not counted. I think in addition, for half an hour, he's locked in another room to do chores, to clean the toilet. So we haven't counted that half an hour. So this is a period when he's unlocked. But it was also said there were significant differences between the MCBS unit and the CSC, and reference was made to Mr. Waldron's statement, paragraph 18. I thought it may have to turn this back up again. So the supplementary bundle, page 25. And the 2R1 is the legal issue, which is about whether there is a power for someone within the CSC to be held entirely separate or not. So that's the legal issue we're concerned with here. The other difference is that prisoners in the CSC are never given an opportunity to interact with prisoners outside of the unit, whereas the MCBS unit, they can be. But again, well, for our purposes, the question is what conditions was this Mr. Syed subject to, and did that count as removal from association? And for those purposes, what matters is the conditions that he was subjected to within the unit, and he wasn't allowed out of the unit at all for the first 3 months. So again, the question is that removal from association or not? As far as he was concerned, the regime he was subjected to was virtually identical to that which he would have been subjected to in the CSC in terms of association.
But this all depends on the meaning of the rule, what we determine that to be.
Well, Lord, yes, it does. But it goes to our point, this is again back to the Padfield point, is if in effect what you're doing is placing someone in a regime which is so similar to the CSC, in terms of their level of association, but outside of the statutory scheme, is that, in the Padfield words, to thwart, run counter to that scheme. So it depends on what conditions he was subject to.
So there were 2 points. I didn't really get them. The second point was that for about 3 months, he personally wasn't allowed to go outside the unit. You had a prior.
Well, yes, these were just the two distinguishing features identified by Mr. Waldron in paragraph 18, which are the ones relied on.
So what is the first point?
Well, the first one is essentially the legal dispute between the parties. It's that in the CSC, prisoners can be held completely segregated, and that's the question is whether that is what removal association means or not is on dispute. We accept that is how the CSC works.
Yes.
The second difference is potential to leave the unit.
Yes.
But our case is simply one looks at the regime to which he was subject.
For your cases, association is normal association. If you're right about that, then clearly Rule 45 and 6 has to be followed.
Lord, yes.
But you've got some other case of you feel wrong about that's how it
No. It's the same point. It's simply why we say we get to where we get to, and again, it's back to it's a Padfield point about.
You keep saying it's a Padfield point. Can you encapsulate your proposition?
That you can't remove from association unless you do so in the way set out in Rule 45 and 46, because that is to run counter to thwart the purpose of the provisions, which is set up a scheme whereby people are removed from association. And our point is that in this case, in particular, when one is so close to what is in effect CSC, the Rule 46, and holding people in those conditions, one does need statutory authority. Which links in well, and the reason I make that point in addition is how we deal with what we say are some of the various potential borderline cases. There may be tricky cases on the borderlines, exactly whether it's removal from normal association in my language. We say also tricky borderline cases on removal from all association. Yeah, but that's why it's coming back to the similarity with the CSC, with Rule 46. My Lords, in terms of association within the segregation unit, association within the CSC, it was accepted, of course, that prisoners can be allowed to associate within the segregation unit. It was accepted they remain subject to Rule 45 throughout. It was also accepted that the 45.1 test has to be met at the outset, 72 hours, 14 days.
I think that Nadir suggested I'm wrong. It was accepted that it had to be satisfied at all times.
Yeah, well, yes, no, precisely, but yes, including at those stages. And the reason that is said to be met, even though on the Secretary of State's case a prisoner is not removed from association, is because it is said that when one looks at 45...
Sorry, can you repeat that? That was a slightly complicated sentence. Could you start that again?
The reason that 45.1 is said to be met, even if a prisoner is not removed from association, is that 45.1 is concerned with authorisation, not actual removal. But if one was to turn up 45.1, I know you've seen on a number of occasions, but tab 1 in the authorities fund, that's what the one that's been marked up. That is obviously inconsistent with the statutory language, because it does not say, I think the submission I wrote down is you have to read that as where it's desirable for the authority for removal for association to inure, then etc., etc. Well, that simply isn't what 45.1 says. What 45.1 says is where it is desirable for X work, for maintenance of good order, etc., that a prisoner should not associate. And by definition, in a case where it is regarded as acceptable for a prisoner to associate, 45.1 isn't satisfied. One needs to read 45.1 entirely differently from the way in which it's put down on the page.
Are you going to deal with 45.3?
My Lord, yes. Again, well, firstly, that gives a power to return to normal association. So, to that extent, it doesn't produce a difficulty. One can entirely fall out of the regime, and that's what 45.3 allows the governor to do. It allows the governor at any time.
How does that work on 46.3?
Well, I'll come to 46.3 in a moment. I appreciate it is more difficult on 46.3, but 45.3, we say, isn't a difficulty. I'll do all my learned friends point on 46.3, but 45.3 simply enables the...
You said it's just going back to the mainstream regime.
The problem you've got, and I think it is fair, it would be odd if there was a difference, as Sir James said, how to do it with 45.3 and 46.3, is that if you treat that as normal, where's the authority lie for the governor, the Secretary of State, say, well, you can't have normal relations, but you're no longer going to be isolated. We want a restricted regime.
45.1 on our reading, because that is what 45.1 enables him to do. 45.1 enables him to be removed from association. We say normal association. So what that enables him to do is to take out of the normal regime.
So you say that it's not a problem under 45 because that intermediate stage is already dealt with under 45.1.
Yes, that is what we say removal from association means. So it enables a governor to take a prisoner out of the normal wing, remove him from association, and hold him in the segregation unit.
I see.
And in terms of, if one thinks through what, apart from, we say, in the first place, it simply isn't desirable for there to be an authorisation. It is desirable or it is desirable that the prisoner should not associate. If one starts to think about how the regime is going to work on the Secretary of State's case, we say it simply falls apart. What it must be is some sort of rolling, there is a sort of potential rolling authorisation that the governor has to take people in and out of association. And on his reading, that has to be mainstream association, because he says no particular legal concept of normal versus non-normal association. So the way he says this works is there's essentially an ongoing authorisation, and then the governor can decide whether a person is to be...
I don't think Sir James is saying that at all.
I may have misunderstood his argument, my lord.
He was simply saying that you have a general rule which gives the governor control, stage one, and at any moment thereafter, the governor may at his discretion allow a prison to have certain privileges.
Well, yes, but presumably, but what he's allowing him to do is to no longer be removed from association.
That's on your construction.
Well, no, I think, as I understand it, he's saying that the authorisation is to remove from association, and it is up to the governor whether he remains removed from association or not.
Exceptions from that state, but he can always be removed, he can always be returned to the original authorisation.
Well, yes, that is how we understood it, but that means the way it operates is you have an ongoing authorisation, and the governor can then decide whether the prisoner should be removed or not removed. That is how we understood the case was being put. That is how Rule 45 works. So you remain subject to Rule 45, provided you have this overarching authorisation, and then the governor decides you can associate, or I'm going to have you removed from association. But we say there is no trace in the Prison Service Order 1700 is that is how it operates, and we do say that is unworkable, and it's also, we say, odd that if one has all these concerns about prisoners held entirely in segregation, which is how it was put by Sir James.
Wait, you said there's no indication where? You say it's unworkable, there's no indication...
In Prison Service Order 1700, which sets out how this regime operates.
No indication in the prison...
Prison Service Order 1700. This was tab 22.
Oh, I see. Yes. I see.
And we say the position would be, presumably again, that the governor can decide to return a prisoner to ordinary association, but he remains subject to the Rule 45 rule, because it is in principle desirable that at some point he can be removed from it again.
As I understand it, Sir James was not saying that the prison governor has to return to ordinary association or the mainstream association. He can simply allow him certain particular privileges from time to time.
Well, yes, but he draws no distinction between normal association and those privileges within the unit. That has to be his case, because my client was in that position as well. He had that form of mini-association within the unit. So we do say his case has to be that it doesn't matter whether it's within the unit on the mainstream. Once you have association, you're not removed from association. We say that simply isn't what Rule 45 says.
So I understand what you're saying. That's how I can in your case, and as I said, in your case, and Greg Graffin on this point. You're saying that if your understanding of the Secretary of State's argument is that you can remain within the authorisation for the 72 hours, 14 days, 42 days, whatever the different periods are, under Rule 45, while at the same time the governor can, at any time, allow any degree of association from restricted, minimally restricted, not restricted at all, on the basis that they want to monitor how they get on. And so, if you, as I think this is your submission, that would be a very odd situation, you're saying, because you could, in theory, that doesn't sound very likely, but you could, in theory, with this authorisation floating above you, say, well, I want to see how they got on by being restored to the ordinary wing.
Well, yes.
And you know, if there's a fight that turns out, something like that, I'll simply bring him back. I don't need a new authorisation. I'm simply operating under the old one.
Well, yeah, that must be what it means. We say.
Yes.
Yes, that is my submission, my lord, yes. Put much better than I did. That is encapsulated.
I don't think it's right.
No, I know. No,
That's your submission.
It was summarised better than I had summarised it. My lord, yes, that is it. And we'll finally on 46.3. Again, my lord, we say there isn't a difficulty for our reading on that, because a prisoner is removed from association under 46.1 and is able to resume association within the unit under 46.3. So they are able to associate in the unit. Everyone accepts association can be simply any contact between prisoners.
So you're saying association has a different meaning?
No, it's always the same. Association simply means contact between prisoners, contact and interaction between prisoners.
I thought it meant, in your case, it meant normal association.
Mainstream
association.
removal from association means removal from normal association. Association simply means any interaction between prisoners.
So that's a bit complicated. I'd understood you to be quoting before a definition, or you were light on this definition, in the NOMS review document. I'd understood you to be saying that association here means normal association with other prisoners.
Removal from association means removal from normal association. Association itself is, as Mr. Justice Lewis said, it's simply any interaction between prisoners.
So, right. I hadn't understood before this subtle thing. So, removal from association in 45.1 and 45.2, 46.1 means removal from normal association. Yes.
We accept that what goes on in mini association is association.
But association, as a word, simply means any interaction.
Yeah.
I hadn't noticed that.
And my Lord Sipper said the difficulty with 46, again on the Secretary of State's interpretation, is it's 46.2. It's the renewal once you're in. Because again, it has to appear desirable, and it's desirable that the prisoner doesn't associate.
I'm not quite sure. Can I just press you a bit on
Yeah.
46.3? If removal from association means removal from normal association with mainstream prisoners, then surely resumption of association must be resumption, the reversal of that, which is the resumption of association the resumption of normal association with mainstream prisoners. It's the reversal, isn't it? One is the removal and the other one is the resumption. One would have thought the one was equal to the other.
Well, our submission is that doesn't necessarily follow. What this enables a CSE to do is to take a prisoner into the CSE where we accept they can be held without any contact with other prisoners. They can then resume some association within the unit. But our submission is they remain removed from association. And that's why they can still be subject to 46(1). Or as we say, they can't be.
Anyway, that's how you get the answer.
So it is equivalent to saying, as you just said, shall assume some association in 46(3).
Well, yes. But you remain subject to 46(1), which is desirable that you be removed from association, because that's they're talking about removed from normal association. Those are my submissions on 46.
Article 8. The only issue you will know under Article 8 is whether or not it is engaged.
Yes.
And the reason that's the only issue is because the learned judge found, and we've accepted, that this was not in accordance with law. And my learned friend accepts that the Article 8 interference, if there was one in Article 8, is engaged, was necessary and justified in other respects.
Presumably a legitimate object.
Presumably it's a legitimate objective and
Necessary.
necessary. So the sole question is whether or not there is engagement of Article 8. And the Article 8 right, as you know, in relevant part, is respect for private life. And the reason that the issue is a tolerably short one is because it is fair to say that the case law has been drifting quietly against me. And perhaps the only two authorities we'd invite you to read, which will place you into the position of principle, as it were, are firstly the judgment of Mr. Justice Singh, as he then was, in Dennehy. And secondly, and I'll go back to Dennehy in a moment, I'll invite you to take it up, but secondly, the AB case, the Lord Chief Justice, the recent case that was meant to come on after this, but came on before because of listing issues. Can I invite you to go to tab 13 in the authorities bundle? And this carries more than the usual weight of the High Court judge's judgment, because in the AB case, as you may have spotted, Lord Justice Singh and the other members of the court agree with Mr. Justice Singh in relevant part.
I thought that was a technique that really began and ended with Lord Denning. Obviously not.
I say nothing about it. It's the normal part of judicial functioning. Is the way I see it. You will see the nature of the facts and the issue from paragraphs 1 to 4 in the judgment. Can I just invite you to cast an eye down there? So this was a Rule 45 case. You see Rule 45 cited in paragraph 9. You see the reference in paragraph 3, claimed to have been what is commonly called segregation, brackets, strictly removal from association. And then the issue in relation to engagement of Article 8 is picked up in paragraph 130 of the judgment. And I'm hoping you have about 3 and a bit pages sidelined. From there, pretty much down to the end of 151. and I don't invite you to read it all now, but what Mr. Justice Singh does is to analyse Munjaz. Munjaz was a House of Lords authority involving, as it's put in 133, the segregation of a patient detained in a mental hospital. That's the context. And there was some doubt and disagreement amongst their lordships as to whether or not, in those circumstances, Article 8 was engaged. And you can see, if I may just cast the dilemma in this way, you can see the dilemma that that issue gives rise to, or the questions that that issue gives rise to, and the doubts and the subtleties, as it were, most clearly, perhaps, if I invite you to read the two passages from Lord Bingham's speech that are cited in 134 and 135.
Where does the Bournemouth line of cases fit into all this?
Where does the Bournemouth line of cases?
Yes. No, you know, those are the ones about under Article 5 and more isolation of very seriously ill mental patients, because there it's been held that Article 5 is engaged. Is there
Well, that's, I think, they're presumably, I don't have them in my mind, but they're presumably to do with whether or not there has been a deprivation of liberty.
it's a deprivation of liberty?
It's a pure deprivation of liberty point. Here the point's slightly different, because the right in Article 5, as you know, is cast in terms of deprivation of liberty. You have to establish that, and there's a distinction between that and restrictions on freedom of movement. And normally that dilemma arises in the context of Article 5, because there was a non-UK signed up to a schedule to the convention which contained or drew a contrast between deprivation of liberty in effect and restrictions on freedom of movement on the other hand. And so if it's restriction on freedom of movement, it isn't a deprivation of liberty, so that's on that cusp. Here, you've got the right cast in a slightly different way, which is respect for private life. And the question is what that means. Sometimes, as you see from those passages in Lord Bingham's speech, it's tempting to think that if you drift too far down that road, you end up blurring, as it were, engagement and justification.
No, I suppose I'm right, and I was asking, I think, a slightly more conceptual question, perhaps I shouldn't have, which is, well, if somebody, as is indeed the case, where there's seclusion of a very seriously mental patient for their own benefit, and that amounts to a deprivation of Article 5, isn't that automatically an interference with that? Wouldn't that conceptually automatically be an interference under Article 5 as well?
It wouldn't. I'm sorry if that was the conceptual question, and the answer to it is no, it wouldn't. And the reason it wouldn't is because it plainly would be a deprivation of liberty, but the case law establishes, and I'll give you the reference, it's in Daly that we cite in paragraph 30 of our skeleton, the case law recognises that if you are placed in prison pursuant to a lawful court order on conviction or on sentence, you are certainly deprived of your liberty. But there is, as it were, the control and maintenance of good order and discipline within the prison system is a necessary concomitant of that deprivation of liberty. And it exhibits, as a result, no interference with the respect for private life, because it's just a necessary ingredient of being sent into prison. So you require the something extra. And the question is, what is that something extra? And most of the cases, not all of them perhaps, but most of the cases in which it's been held that there is an interference with the right to respect for private life have involved the something extra being segregation. So that, I hope, is the answer to the conceptual question you raise.
Yes.
The reason I'm taking you to this passage is because that sort of dilemma, that sort of thinking, comes out from those two passages in Lord Bingham's speech, where's the problem? It doesn't show any lack of respect, he says in the first one, for the patient's private and family life if it's used as a means of protecting violence to seclude someone in a hospital. There's no lack of respect in that part. However, you can have it in some situations, is the answer. But the reason for going to this passage is because what Mr. Justice Singh is doing is to analyse whether there was a majority in the House of Lords for segregation, the context of his case, involving an interference with Article 8 rights requiring justification. And he concludes, in a nutshell, that there was a majority in favour of there being an interference. And he does that because, in effect, he says, Lord Bingham is sitting on the fence and doesn't decide it, so he can be discounted from the equation. Lord Hope is pretty much again there being an interference, and the other three, Lord Scott, Brown and Steyn, are in favour of there being an interference in the context of a segregation case, and hence he accepts the submission made by the claimant in that case, paragraph 144. And for good measure, he says, when the thing went to Strasbourg, they agreed with that identified majority and concluded that there was an interference. So Munjaz against the UK as Munjaz, House of Lords off to Strasbourg. But they reached the same conclusion as the identified majority in relation to that. Now there's a question as to whether or not that's a correct analysis of those judgments. But in the light of AB, that's not an issue which I pursue before you.
So the Court of Appeal said it is.
Exactly. That's Lord Justice Singh agreeing with Mr. Justice Singh, which I'll come to in a moment. But so there's a majority against.
That's despite your sophisticated analysis and your skeleton, which puts a different spin on.
Well, exactly so. I'm not sure I claim an enormous amount of credit for that. A, because Mr. Sharland drafted that skeleton, but B, because it looks a bit like a recitation of Mr. Weisselberg's argument. I'm told he copied it from him. Anyway, there was a degree of copying. You'll see Mr. Weisselberg's submissions in AB in a moment. But yes. For good measure, and before we leave this judgment, if I may, just to put you completely what you ought to see, 149, he notes an acceptance in the Shaheed case, to which you've been taken already today, the Supreme Court case of the concession that had then been made by the Secretary of State, recorded in Lord Reed's judgment. Segregation is an interference. Right, so that is that and Munjaz. AB is behind, I think, tab 14A. I hope that's right, I've got it loose. Yeah. So Dennehy was a woman prisoner subjected to Rule 45. AB, as you see, is the equivalent, as it were, in the young offenders institution context, as you see from the first paragraph. And can I just invite you to read that to give you a flavour, and then paragraph 3 to show you what had happened below. So the Secretary of State had again conceded, this time before Mr. Justice Ouseley, below that there had been engagement. And there was, no doubt, an encouraged change of heart between Shaheed and Mr. Justice Ouseley at first instance and the Court of Appeal in AB, as one sees from the final sentence of paragraph 9, because the concession is sought to be withdrawn by Mr. Weisselberg, who was representing the Secretary of State. And you see that the concession had been made, para 43, at least before Mr. Justice Ouseley, because of the reasoning of the learned judge in our case. The issue is then analysed at paragraphs 150 through to 161. So those are the key paragraphs for present purposes. And you see the nature of the argument. They certainly got the wrong court for the fourth submission, but if you see the argument at 153, and the first of those points is the Daly point and the Lord Bingham point. It's the recognition that there is the answer to my Lord's conceptual question. And those submissions are rejected, see 155, for essentially the same reasons as Mr. Justice Singh gave in the case of Dennehy. We would hold that Article 8 can, in principle, be applicable in cases of this type. 155, in particular because removal from association with others constitutes an interference with the right to respect for private life as interpreted by the Strasbourg and domestic courts and therefore needs to be justified. And then they specifically agree with the analysis of his, Mr. Justice Singh's analysis of the Munjaz speeches in Dennehy at 158. And they adopt his conclusion at 150, that's the Shaheed point. And then they state the conclusion, or their conclusion at 160. So that's where you are in terms of the principle of it, and my Lord gives me the look that suggests this is not a terribly promising starting point. My submission is that the case law establishes that Article 8 can be engaged in circumstances in which a mental health patient is secluded, or where prisoners are subject to segregation, at least for prolonged periods. And the case law is clear about that. Dennehy, approved by the Court of Appeal specifically, and taken on in AB Munjaz.
Yes.
So we are not pursuing the argument that you see set out at paragraphs 26 to 28 that my Lord Justice Haddon Cave referred to. The only submission I make is that it is proper, however, to recognise the limits of that case law. There are serious and important issues around the drawing of that line, that engagement line. And you see that very clearly from the division between the members of the House and the analysis in the speeches that I took you in Dennehy from Munjaz. And one does start from the proposition that the answer to my Lord's conceptual question is it doesn't follow from the deprivation of liberty that you have an interference, because there are things that are concomitants of being deprived of your liberty in prison.
There are gradations.
There are gradations, and they include the need to maintain proper discipline in prisons. So the question is where you draw that line. Segregation, certainly. Seclusion of mental patients, no doubt. There may be different rules that apply to non-convicted prisoners as opposed to convicted, but there is, nevertheless, a line. And that's why when the Court of Appeal in AB expressed the principle in 155, they did so in the tolerably cautious terms they did. It can, in principle, be. Now, I fully accept that in 160, on one reading of 160 in AB, they've gone further. And they've said, in effect, well, it's because you're interfering with the right to association in 160 of AB. But my submission is that the proper reading of 160 of AB is a fact-specific.
Says we consider that on the facts
exactly.
of the present case.
Exactly. So on the facts, you were dealing there with serious, prolonged segregation. Now, if the position is that even in the case of a mental patient who is secluded for a prolonged period, like Munjaz, there is a genuine dilemma as to whether that falls on the right side or the wrong side, there are serious questions that then arise as to how that all works. And the question, therefore, is whether or not the admittedly lesser restrictions on association in the unit, the MSBC or whatever it was called, unit in our case, whether those lesser restrictions cross that line. They are not the same.
Well, you have to be careful here. At this point, correct me if I'm wrong, you're looking at the individual case,
You are.
not generally, and you have to grapple with the fact, unless you challenge the facts, as they were put to us by Mr. Squires, that Mr. Syed, while he was in this unit, was locked up for between 20 and 3/4 hours and 21 and 30 and a half hours.
He was. He was. And that is a long period. But he was entitled to associate. He was in the halfway house for jolly good reason, because there was a serious conviction for a very, very serious offence of planning a terrorist outrage involving beheading someone on Armistice Day, which he was planning.
You were saying the judge's conclusion on the facts.
I am. I'm saying that I don't challenge his basic factual analysis. These were the conditions. I say that those facts accepted are not sufficient or do not amount to an interference with Article 8. That's the short point. And I do so because the control and discipline of prisoners, by and large, does not involve, even if it involves additional restrictions within the prison service, it does not involve an interference with Article 8. See the dilemma they had even in the context of a seclusion of a mentally disabled patient in Munjaz. And in his case, serious offending, serious intelligence dealing with the need to control risks that he posed because of subsequent threats, as the judgment records, the need properly to manage him, no doubt for his own protection and for the protection of others. Nothing disrespectful, if one wants to cast it in those terms, about a conclusion that the ordinary wing is not the right place for that individual. A conclusion that he shouldn't go and didn't go to the CSC, the most extreme form of segregation, but that he should instead go to the intermediate place, which is the unit.
Well, the trouble is, on that analysis, there's always going to be, there should always be, a very good reason for greater and greater degrees of isolation. So the person who's completely isolated, there'll be very, very good reasons for it. But it can't be obviously consistent with the case law that just because there are very good reasons for it, that doesn't mean that Article 8 isn't engaged. That goes to Article 8 too. And I think you've accepted.
It goes too far if put in that way.
You know,
and
so
I don't.
it can't. I don't think it can simply be. Well, you know, it was necessary because he did this and he did that, or she did this and she did that. I think I think one needs to get further.
Yes. Are the restrictions such as the? And I fully appreciate that you drift from engagement into justification quite quickly on this analysis, but that's just the nature of the beast. The question is, are the restrictions sufficient and sufficiently serious to engage Article 8? That's the question. And the reason for the imposition of those restrictions is relevant to that, as is the absence of any evidence demonstrating they suffer any form of mental health issue. Because most of the time in which those early cases were considering segregation and concluding that they did, after quite an intellectual tussle as to whether they did, the conclusion that they did in those early cases was very much premised on the idea that because of the nature of deprivation of association and the total removal, the segregation removal, that carried with it, as it were, serious risks of damage to the individual. One can understand that. Now, of course, questions of degree, do you get to the same set of risks if you reduce it up, down a little bit? But in the end, we do have here some association, necessary restrictions for good reason. And this is not the same as those cases which do involve segregation of convicted prisoners. This is not the same as those cases. That's why we say the issue is there. I hate reserving points for another court, but you'll appreciate that the Secretary of State does not necessarily accept the correctness of Mr. Justice Singh's analysis of the Munjaz speeches, but that is not for me.
Yes. Do you say there's also a relevant distinction between cases involving seclusion for psychological problems and prisoners who've been found guilty of very serious crimes.
I do.
That's part of the factual.
That's one of the factual elements, and Munja's been over seclusion, and to some extent you'll appreciate, I've already said it, but the significance of Munja's from the perspective of my argument is just how difficult they found it, the Article 8 interference issue, even in that context, where you're dealing with a mental patient. But I think there are some other cases in the bundle, at least one at first instance, so it may not trouble you that much, but at first instance there is a decision involving a non-convicted prisoner. So I do say that all those factors feed in, because the ultimate question is, has there been respect shown, recognising that it's a necessary concomitant of being sent to prison as a convicted prisoner, that your risk has to be properly managed.
The starting point being the daily starting point, that if you are convicted and sent to prison,
There is a concomitant that goes with it.
then by definition you are already restricted.
And subject to ordinary disciplinary processes. That's why they look at the exceptionality of segregation and the kind of mental health risks associated with being deprived of human company for prolonged periods and all of that. So there is a real difference. I mean, I've taken the point I've taken the point as shortly as I have, because I recognise that there are difficulties with the analysis up to a certain point. But the position simply isn't, and cannot in principle be on the case law, that look at it from the other end of the spectrum, that any alteration of your right to associate, that's why I characterise 160 of A-B as a decision on the facts. It isn't that whenever you reduce the level of association, you automatically have a disrespect of the right to private life for that reason.
That's not the way a judge has approached it. He's looked at it factually.
He has. The learned judge here has looked at it factually, and as I say, I hope I made clear, we don't seek to quibble with any of his findings of fact. The question is whether in the circumstances they are sufficient, and that's a question of principle. Well, that's how I put it.
Thank you very much.
Moores, I wonder if we can start with the way Mr. Justice Lewis dealt with this in the judgment, as we respectfully say correctly. It's at tab 7 of the consolidated bundle. And we'll also see this paragraph 57 deals with this. Well, he starts by recognising the point that my own friend made, that there are limitations that are inevitably consequent on being detained, and those will not engage Article 8. He then goes on to say, first sentence, paragraph 58, restrictions which go beyond that may amount to an interference. And then 59, the real issue in the present case is whether they do or don't, whether these are ordinarily consequent, inevitable upon being imprisoned, or whether they're an interference with private life that goes beyond that. And he then sets out an analysis of all of the conditions within the unit, etc., the context of the transfer, all of the points made by my learned friend. And then 63 is the judge's conclusion at the end of paragraph 6, the last two sentences of paragraph 63. And we respectfully, there are no errors, we say, in that analysis. There's no issue is taken with the legal question Mr. Justice Lewis asked, no issue taken with his factual analysis, and we can say there can be no basis for disagreeing with that that conclusion. And we say that is so in particular if one applies the test, the test now that has been applied domestically and in Strasbourg is the test set out in Munjaz in the European Court of Human Rights. And I appreciate the case itself involves seclusion of mental health detainees, but it's been applied repeatedly. It's applied in Shahid, it's applied in Dennehy. It's the same test to detainees in different contexts. And it's clear from that, we say, firstly, that Mr. Justice Lewis asked himself the right questions, but also came up with the right answer. I mean, also, if you could turn to Dennehy, to Munjaz in Strasbourg, it's tab 17. And the factual conditions of Mr. Munjaz's...
Right, so that's what I see where we're getting to here, rather than going that way through Munjaz. Where we seem to have agreement on the case law, it says, and you say Mr. Justice Lewis has looked at the facts correctly, and by the facts to the law. And what additionally are we going to get out of looking at Munjaz?
Munjaz sets out in a little more detail what the test is to decide whether someone who is secluded, segregated, removed from association, isolated, what one is asking to decide whether Article 8 is engaged or not.
We don't get this in the later cases.
It's set out in most detail in Munjaz.
Yeah.
I mean, the first point you make simply on the facts of Munjaz, which is that the conditions of his detention were, in fact, it's said by my learned friend, more restrictive. They were significantly less restrictive than those imposed on Mr. Syed. He is also, during the time when he is not locked in his cell, he is able to associate with other detainees. So it's not a complete segregation case, it's a limited association, and it works out that on average he was out of his cell for around 2.5 hours a day, able to associate, which is similar, but it's for significantly shorter periods. It's periods of a total of 45 days in a year, with the longest being 18 days.
This is Mr. Syed.
This is Mr. Munjaz.
Mr. Munjaz. So when you said he was out of his cell for 2.5 hours, who are you talking about there?
That was Mr. Munjaz.
He wasn't in a cell, he was in a high security hospital.
He was, detained in...
He's not in a cell, he's in a, maybe in a room. It's a hospital, it's not a prison.
Well, it's correct, yes, sorry.
Must be his room.
Yes, well, yes, but my intellectual language not detained in his room.
Yes.
Well, then the analysis, the submissions and the analysis, paragraph 76. The government there makes essentially the same submissions that are made here, which is, well, he would have been subject to restrictions anyway. That's the daily point. In fact, he did spend periods in association. And was then 78 to 80. Sets out the test that's applied, or the way in which the court assesses engagement of Article 8.
So what point are you making on all of this?
The test for Article 8 is, or the issue under Article 8 is this an interference that goes beyond the ordinary interference occasioned by a prison sentence? And that's finally applied at end of paragraph 82. Sets out what one means by private life, its autonomy, ability to develop relationships.
That's why I was interested with the overlap with Article 5, but anyway, that's another matter. I think it's the last sentence of paragraph 80 then. You support, isn't it?
Yes. It's what's involved in Article 8. It's a broad concept. But what it covers is physical and psychological integrity, and then this bit, the right to develop, the personal development, the right to establish and develop relationships. And underpinning that is the notion of personal autonomy. And that is of particular importance at end of 80, when someone has little personal autonomy left. And this was in the then paragraph 82, dealing with why Mr. Munjaz's seclusion was not part of the ordinary conditions of detention. Less than 3% of the detainees subject to it. It's a particular regime imposed for particular reasons.
You talked earlier about an ordinary prison sentence. There are different categories, aren't there? Category A, category B. You may have an open prison. So is it relevant to have regard to the original reasons why you were put into prison, and what category you're put into? Because they vary enormously.
Well, it would. So we would be comparing the interference with privacy that is the inevitable consequence of his prison sentence is, I think he was in category B, I think was his categorisation.
He was Cat A.
I think he was, we can double check, I think he was in B before he was...
He still is.
Oh, no, I think he's back in B, as I understand it.
He's always been B. He's always been B.
So, my lord, it's the interference, that is the interference that comes from his sentence and the conditions which he's held in. The question is this part of that interference, is the inevitable consequence of that, or is it, as in Munjaz's seclusion, something that's additional to an additional interference because it's regarded as necessary?
So stage one, it's ordinary for him, Cat A, Cat B, whatever. And then it's the question of looking at what additional restrictions there are on top of that.
Yes, yes. That's the language used, additional interference, but I accept that it must mean there would be different levels of different prisons, so one would compare it to the regime that would otherwise be imposed on him. And indeed, that's in paragraph 82 of Munjaz, exactly how it's analysed. You look at him being taken in and out of seclusion.
That final sentence in 82, is that right? For prison seclusion as regards additional interferences with the private life of the applicant, which would distinct from the inevitable interference that arose from his detention in high security conditions at Ashford.
Yes.
I think that's what it said.
Yes. So yes, comparing it to otherwise if you were high security detention in Ashworth. And that was, well, it was the reason I took you to that, because it unpacks a little bit what Mr. Justice Lewis was doing, but we say entirely correctly, that is the test. And we say applying that test, he was clearly correct. The whole point of this regime is to take people out of the normal restrictions of detention and put them in a much more restrictive unit, and much more restrictive in terms of the key indicia of private life, ability to develop relationships, personal autonomy, etc.
Is that it?
Well, and no further submission.
Question. The question of justification might arguably come in at two stages. One is the justification for imposing Rule 45 regime. or MCBS. Look at the facts and decide whether or not that is not interference, whether Article 8 is engaged. If it is engaged, then you look at it, you apply Article 8 to the second stage. Is it right that when assessing whether Article 8 is engaged, you look at all the reasons as to why there's been the restriction, including the reason for conviction, whether or not the prisoner is designated as dangerous by the judge at the sentencing moment, and the behaviour of the prisoner in prison, which has led the governor to determine that there need to be further restrictions. Do all those come into the picture when assessing whether Article 8 is engaged?
Our submission is they don't. Our submission is those are all Article 8.2 issues, because it doesn't matter. I mean, in a sense, all of those, if the prisoner is particularly dangerous, etc., that may well justify 8.2, but it doesn't mean it doesn't need to be justified, is there? Because that's where Article 8, because it's, sorry, Bold.
Sorry. If you go back to Daly and that original proposition that if you're in prison, there is a restriction imposed by reason of being designated a prisoner, and you accepted earlier that there were different levels of it, Cat A, Cat B. So the logic would suggest that you have to look at all those reasons as to what led to the restrictions when assessing whether or not Article 8 is engaged in the first place.
In our case, you don't seem to look at what you would look at is what would be the conditions of the prisoner's detention ordinarily. And for this particular prisoner, and except that will include, that will be determined by his index offence.
And all the other factors. When you say ordinarily, it's ordinarily for him.
Yes.
Accepted. Therefore, you look at all the factors which led to the imposition of the restrictions at that first stage.
Well, yes.
You may come back to them if Article 8 is engaged. The question I wanted your answer to is, do you accept that you look at them at stage 1 when deciding whether or not Article 8 is engaged in the first place?
You look at them to decide what the baseline is of the conditions to which he would be subject. When you decide whether additional restrictions engage Article 8, our submission is they're not relevant to the engagement, they're relevant to justification. And certainly we see from the case law here that there's no suggestion, for example, Shahid, Dennehy, these are all some of the most serious offences. There's no suggestion that was regarded as relevant in the question of engagement of Article 8. It became relevant when we look at justification. So we do say once one is looking at whether the additional restrictions engage Article 8, we say one doesn't then say, well, this might have been, this depends on whether it's how dangerous the prisoner is my submission.
I think it's the bigger point, really, that I was trying to articulate.
It is, and that's dealt with in Munjaz at 81, where the European Court of Human Rights says, no doubt more clear than me, but why they consider that as a justification question, not a 8.1 question dealing with what Lord Bingham said.
Are there two stages? One is you're put into prison, category A, for the sake of argument, or you have an inevitable interference with your private life in detention in high security. It's then decided because of your conduct, and because you are, maybe almost instantly, you're put straight into the higher regime. Again, the question is, are the reasons for doing that part of the calculation as to whether Article 8 is engaged? Because the reason is an extremely good one for interfering. So I haven't put that very well, but
yeah.
Do you look at the question of why the person was restricted in this way when deciding whether or not Article 8 is engaged?
Our case is, my lord, that you don't. If you mean the act, you say once you went into prison, some act of violence.
At stage 2, yeah.
We say at that stage it doesn't go to engagement, but obviously it's going to be critical to justification.
You look at the nature of the restrictions.
You look at the nature of the restrictions and whether they...
Only once you're in prison.
Well, my lord, yes. And that certainly appears to be the way in which the case law applies all of this. You look at the nature of the restrictions, whether they go beyond the inevitable, but then it's just the nature of the restrictions, and then they need to be justified when, at that stage, all of the analysis comes in.
It's curious that, isn't it? Because at stage 1, when you're being put into prison, you do look at the reason for being put in. At stage 2, you don't, for the higher restrictions.
Well, with stage 1, you're looking at what are the inevitable consequences of being in prison, and that, I accept, will include what is imposed on prisoners who've committed what you've done with your level of risk, when you then decide to impose greater restrictions.
But if you apply the logic of it, stage 2, if the inevitable consequence of fomenting a prison riot or threatening to behead prison officers is that you're put into CSC, why isn't that then relevant to the analysis?
We would say that still needs to be justified, placement in the CSC. It would still engage Article 8. Well, we still need to that move from the inevitable consequence of the incarceration. And the further point I would make is, of course, all of these restrictions all of these CSC, MCBS unit restrictions are far beyond what any prisoner, simply by reason of their underlying conviction, would be subject to. So one has people convicted of the most serious offences, the most dangerous, who will not be in these units. It's a separate decision made, and my lord saw the criteria for the CSC, it's conduct in prison, that then leads you into these units. So that's why we do say it is a separate stage, and that has to be justified.
My lord, the only thing I would say in the light of that exchange is that there is then an oddity. If the position is that you look at all the circumstances of the individual prisoner for the purpose of working out what is the concomitant that goes with his incarceration at the outset of going to prison, as my only friend appears to accept, then that creates some real interest. It acknowledges that you can look at the individual circumstances and seriousness of the offence. And it acknowledges that you might well have no interference with Article 8 rights on that basis if the seriousness of the offending and its circumstances are such as to require you to be placed, for the sake of argument, immediately in the CSC. Now, if that is right, and we submit it is, that that's simply the concomitant of the imprisonment of the individual prisoner, including all the circumstances, including seriousness, then it becomes impossible to understand why those same circumstances, or similar circumstances relating to the degree of risk, would not equally be relevant the day after. But it also creates a point of real interest on the facts of our case. Because if I've understood the chronology correctly, what actually happened in relation to this individual is that once he was convicted and went to the prison he went to, he started off on Rule 45. Went in and then Rule 45. But the move that we're worrying about is a move the other way. It's out of Rule 45 into the intermediate stage before hopefully going back to wing. And that also, we submit, is a relevant circumstance in terms of identifying whether there has been an interference. That's all I say.
Just to add to that, if the inevitable consequences of your behaviour at stage 2 in prison is that you're put, because you breached into a more restrictive regime, logic would suggest that that was relevant.
That's the submission I make. And because you can't sensibly distinguish between the initial and the subsequent, and because all the circumstances play into whether or not there's been a lack of respect for private life. Now, my learned friend pointed to Munjaz, as you're aware, and said, well, there it is, the answer's all in Munjaz, it's whether it's something additional. Well, here we haven't got something additional, we've got something lessening, because we're going to the lighter regime in the MSBC or whatever it was. But the point remains the same. It must be all the circumstances. And then you work out whether that's a concomitant of the imprisonment or not.
Ironically, there was no complaint about the 2 years in Rule 45.
No, none.
Thank you all very much for your submissions. We will consider our judgments. When you get the draft judgments, please do agree with form of order. No further submissions.